Hi, this is Rob Wells here with you from the Law Office of Robert M. Wells. Our office specializes in landlord and tenant issues within the Solano County area, which is in the San Francisco Bay Area. In this video, I'm going to talk about whether or not a landlord can text message his or her tenant a termination notice. Sometimes we do get this question from time to time, and I get a landlord that tells me, hey, I just gave my tenant a 60-day notice and I just texted it to them, and what can I do? Can can we file the eviction? It's going to expire in a couple of days. And I tell my landlord, unfortunately, that's not going to be legally sufficient. And they're surprised. And the long short answer that I have to tell them is, listen, under the California Civil Code, Civil Code 1946 and 1946.1, there are four methods of how a landlord can serve a termination notice. And the long story short of it is the four methods are either personal service to the tenant, meaning you give the tenant an actual piece of paper that terminates their tenancy in person to them. If personal service can't be done, then there's what's called substitute service, meaning you go to the tenant's home or at work address and you can't find them, and you give another adult or person that looks like they're in charge the notice, and then you mail a copy of the notice to the tenant. Or what's most commonly done in our business is what we call post and mail the notice. And this method is used where you go to the home, for example, the tenant's residence, you knock on the door and no one responds. So what you have to do is you have to post the notice in a conspicuous place like the front door of the premises, and then you have to mail a copy as well. That's another form of service. And then the last one is probably the most simple of them that's allowed for giving termination notices of terminating a month-to-month tenancy would be by certified or registered mail. Those are the four methods. As you can tell, there is no text messaging the tenant in the Civil Code. And until the legislature allows for electronic service of a termination notice for residential tenancies, you gotta just use one of the four methods. I mean, the Civil Code was created like in the 1850s. That's kind of, it's been amended from time to time. But in the legal world, it hasn't really caught up with technology. So we gotta stick to what the code says. Because if you don't properly serve your notice, your eviction case could be defective and it may be thrown out of court. So listen, it's going to tell you, if you have an issue where you need to issue a termination notice or you're contemplating that, it's probably best that you talk with seasoned legal counsel. The reason why I say that is, listen, with all these tenants protections now in place, issuing a termination notice, especially without the requisite language or disclosures that need to be provided to a tenant, could cause you legal headaches down the road, meaning either the case may be thrown out down the road, or a court may state that there was inadequate notice to the tenant that you were terminating their tenancy. And you don't want to end up there, because that means more delays equal more cost to you, and you might even be on the hook for tenants' attorney's fees and so forth if they have to get a lawyer and so forth. So my recommendation is, if you have a situation like this, you might want to consult with legal counsel before you do anything. And if you don't have legal counsel, please feel free to give us a call or contact us down below, and we can go over your case with you. Until next time, we'll talk to you then. Take care.